Is it raining in here, or is there like you got a bucket hat on?
Oh, I know, because I'm on vacation. By the time this goes online, I'm going to be swimming in the beach.
Right on. You deserve it.
Yeah, I know. I just hope the sharks don't get me.
Okay, so I have not been following closely. We haven't the Hockey Canada case in London, but there's a few things that we've spoken about, and I was on with John Oakley, I think Friday, on his show.
It would be like probably 2 Fridays ago, but
yeah, that's true. That's right. And I'm angry, and my fear about this case is that we're going to have Ghomeshi 2.0. Okay. That because there is so much vitriol and protest and shit and emotion about what should be obviously acquittals in this case, that we're going to get some asshole in government saying we're going to create a new piece of legislation to make it easier to convict in certain cases. And here's some lines from media reports that I was talking about. And I was very thankful that Oakley was talking about this because he had the intuitive sense that this smells bad. Consent videos not viable as evidence in court, experts say after Hockey Canada trial.
Which experts? We'll get to that later.
We'll get to it. You know,
So that headline is saying that consent videos in which a complainant is saying, yes, I consent to this, that they're not viable or admissible or shouldn't be.
Correct. And they're not viable, and because they're not viable, they shouldn't be admissible for all host of things. And
that's a video in which you actually have the complainant saying, yes, I consent to this.
Yeah, so there's a number of videos in the trial. Again, we haven't followed it, and
well, we only know what the news is reporting.
Well, I know a little bit more than that, but tangentially, there's at least some with respect to the complainant and sex acts, and then there's a video after sex, a second video that has the complainant in a hotel room, covered in a towel, saying, "Are you recording me?" Okay, good. It was all consensual, and this is just one video that the protesters outside and then these so-called experts glom onto. And there's 2 videos, I think, in particular that have been submitted in evidence where they're being relied upon to establish that, in fact, there was consent, okay? And the complainant testified that she didn't remember either video being shot, but that she felt intimidated and would have said whatever the players wanted her to say or were coaxing her to say in the video. And a Crown attorney in the case argued that the players would have recorded the videos only if they thought there was a possibility that the complainant would later say the sexual interactions were not consensual. And one of the players, the only one who testified, pushed back in cross-examination saying consent videos are common among professional athletes. And just give me a couple more, because this was my blood vessels were enlarging.
So are mine.
And consent videos are recordings usually taken before, during, or after a sexual interaction as a means of documenting consent to preempt false allegations. Under Canadian law, these videos don't hold up as proof of consent, which needs to be continuing, voluntary, and can be revoked at any time. Not completely true. So you can have a fucking video of a complainant saying everything was totally consensual or I'm consenting to sex. It is some evidence that there may be consent at the relevant time. So the way this was reported was conflating 2 issues. Consent has to be timely at the moment of interaction and throughout the interaction. So you have to consent to each and every... Active and ongoing. That's true. But a video that says, oh, everything was absolutely consensual, I had a great time, thank you, this was really wonderful, is still fucking evidence that somebody may have consented. Period. And it's up to the trier of fact, whether it's a judge or a jury, to determine what weight to put on that after there's been evidence in chief from the complainant about the video and thorough cross-examination about it. And the lawyers will make the argument, and the judge or the jury will decide how much weight to put on the video. But it is a highly relevant factor. What's important about it is it's a real piece of evidence. It's a video, real-time evidence with the person on it. And remember, in this case, there's also issues about capacity and their lucidness. So if you can see them talking and articulating well and moving while they're giving the video. Being responsive
to a question.
Being directly responsive to the question. Good point. These are all relevant factors to consider. This is real evidence. which should not be excluded simply because a certain group of people don't like them.
So the complainant's welcome to respond to that evidence when it's put to them in cross-examination. They're welcome to respond by saying, I was scared and I was afraid I'd be hurt if I didn't say what they wanted me to say. They're welcome to say that, and then the trier of fact can decide what weight to put on their explanation for it. But again, like we just said, the fact that she was responsive to a question addresses a secondary issue about capacity.
But what I can't stand here is how the media picks up on these so-called experts. So a law professor at the University of Ottawa was saying, because of the strong protections we have, courtesy of the Supreme Court, around sexual encounters, you're not required to say no, no, stop. Yes, that's true. We agree. So having on video a person who's seemingly participating in a sexual activity and not protesting, screaming, pushing the person off doesn't indicate consent.
Well,
that's not enough to have consent in law. Thanks, Professor. We know what consent is in law in Canada. But if you have a video of somebody engaged in sex, actively participating, moaning, doing shit, not just lying there passively, there's more to something than just somebody not protesting, screaming, pushing the person off. There's somebody who is actively engaged in a sexual act. Well, that's evidence of consent. I'm sorry.
One of the things that
I don't like the way this was framed.
No.
Because what they want to do is, if there's acquittals here, what they want to do is push for legislative change as to how these videos will become admissible into evidence. I smell it. I know it. That's what I said on air. I've been saying this for a little while. It's where you have these high-profile, bad fact cases that should not be brought, and you get shit law out of it.
Well, and when we'll get to the potential concerns about legislation being passed, kind of like what was called the 𝐵𝐼𝐒 rules that brought in new legislation. Yeah. We'll get to the concerns about that in a moment. But what also concerned me about this initial article was they start talking about people who have been encouraging what they call the Manosphere.
Yes. Talk about this a little bit.
Yeah.
Because there's the influence of the internet and all sorts of proliferation of concerns about allegations of sexual assault. So this has been going on since the early 2000s. Talk about this.
So they talk about like the red pill community, the Manosphere, and specifically use the word misogynists, right? So my question reading this is, I'm sorry, men who want to guard themselves against false allegations, how is that misogynist? Like, it's really, it's a manifestation of the current world that we live in which false allegations will be prosecuted, can affect anybody. And young men are concerned for their futures. And so, yes, they've gone online and they've talked about what can we do to prevent this. And, there's been things like always be recording, and we've talked about that because now if you're always recording everything, you could get charged with voyeurism on top of a sexual assault charge. Trying to figure out how to protect yourself, to protect your future and avoid somebody, because people do, whether it's smart or not, they do have random encounters with people. Yeah. And in this case, that hockey player saying athletes have actually, it's very common practice to get consent videos because we're targets for people who may take advantage of us for monetary reasons, to try and extort us and things like that, that it's actually becoming common practice. Why is that wrong? How is that misogynist?
There's Dave Chappelle did a sketch where he is asking a prospective partner to sign a lengthy contract outlining exactly sexual activities that are approved. Hey, hon. And then initialing and signing each page and each act. And that's because we came, there was the Me Too movement, which was important with respect to dealing with dark areas, abuse of power, misunderstandings about inequalities and abuses that go on behind closed doors and all that.
Sexual assault.
Absolutely. But the flip side of that as well was that we saw cancel culture, allegations being made, people not even being charged, their lives being ripped apart, false allegations. The argument, we'll talk about it in a moment, that there's no false allegations is a complete lie. And so there was a lot of discussion on the internet about, like, how do we protect ourselves? How do we deal with this? Because sometimes people do engage in one-off encounters, and anybody watching this who's like in their 40s, 50s, or 60s might go, yeah, I mean, that used to go on years ago. Not that it was necessarily wrong, but how do you deal with it? And so some men have been very worried about it. And as we've said before, some celebrities or athletes are worried because they could be targets. But the way this is framed by these so-called experts is they're looking at these areas of concern, and they're saying these online spaces where these men talk about these issues are misogynist, that they're essentially rapists, they're misguided. And despite the fact that false sexual assault allegations are the minority, pickup artists, dating coaches, and men's right influencers have touted the videos as rape insurance to protect young men. Well, that may be stated on the internet, but that does not encompass why this is happening or why somebody would take a video.
Well, when complainants take videos of somebody, there's no motive question as to why they're doing it. Even though...
Or they record a conversation, or they make accusations in a message format.
Surreptitious recordings.
Surreptitious recordings.
Quite often. Nobody questions their motive. Why in the world, is it nefarious for a young man to try and protect themselves when they find themselves in a sexually explicit situation and they're just worried? It was like, you're okay with this, right?
Yeah, and
it's not nefarious.
And let's be clear,
it's practical.
We've heard of in prior years, particularly in the United States, that there was pre-sex arrangement contracts that were drafted that professional athletes were using, and to insulate themselves from maybe civil lawsuit or criminal charges. And, time has moved on, but the way this is framed, particularly now, because of this trial in Canada, it's framed that the only people who would use or take such a video are those that know that they have done something wrong and are guilty of a sexual assault.
They're framing it as a guilty mind.
Yeah.
And, again, it's like presumption of guilt throughout the entire thing. Why would you record consent unless you're guilty? Is essentially the argument that the Crown is making, and that overrides the principles of our legal system. And it leaves you asking, what can somebody do to protect themselves against a false allegation? We're back to square one. Because it seems to me, with these arguments, that anything you do will then be turned into some sort of presumption of guilt. You wouldn't have done that.
One of these experts,
if you weren't
one of
guilty.
these experts clearly is quoted as saying, the question that always follows these videos is, why did you feel the need to make one? Why would you make a video of if everything's going to go the way you described? Why would you ever need to take this video? In the Hockey Canada case, lawyers representing the accused sent the videos, to the Globe and Mail, arguing that the footage showed the sexual contact was consensual and that the complainant was not fearful, intimidated, or intoxicated as she claimed. The Crown argued at trial that the videos were evidence that the players were unsure if their interactions were fully consensual. You see how you can put the spin on this?
Right. And it is spin. I mean, it is what it is. And, my problem isn't...
I got to say more. I think the people who take these videos don't understand what consent truly means in sexual activity, said law professor. They sort of feel like they've got themselves covered, but in law, there's no significance to these videos.
Well, that's something to be argued about, what you can make of it or not make of it in submissions. What we're concerned about is legislation being passed similar to the 𝐊𝐒 rules.
No, but what I want to push back on is, I clearly, and I think I said this in the interview, clearly the optics of some of these interactions are not great, right? But it goes on, and we have human nature. And it may be that a certain person really wants to be with 2 or 3 athletes, and that's something they want to engage in. More power to them. That's up to them.
Or just get caught up in the moment.
They're caught up in the moment.
And do things they wouldn't normally have done,
People have all sorts of desires and interests. It's not for us to say one versus the other. And we can all agree that, 5 people having sex with one particular young woman doesn't look great, but there may not be nothing nefarious about it. So it certainly doesn't mean it's illegal. And just because the optics aren't great doesn't mean if they took a video that it means that they are concerned because they don't understand what the concept of consent is. No, they do. They're just worried sometimes that somebody later on will then relabel what happened, sue to make money, and then claim sex assault in a criminal court. That's what they're worried about.
Well, I think there's an aspect too, in that sometimes people decide to do something, and then the next morning when they get sober, they regret what they did. And
we have a case now.
There's a lot of motives that can be
We have
at
a
play.
case now where we believe it was an absolute setup, where we have a client who is a wealthy club owner, where somebody sought them out and they have sex, and then afterward there's an extortion.
Immediately afterwards, ask for money.
Money.
Yeah.
Okay. And of course he didn't take videos, but we were able to pull down from the club videos of the complainant and the client going in and out of the room where this occurred, and you can see they're holding hands and they're smiling and laughing.
Described.
Completely different than the narrative of the complainant. Mm-hmm. So again, the pushback is, it's not true that a false allegation is rare. It happens more often than one would think. And 2, we do have cases where people do this for the sheer reason of wanting to gain money through an extortion. And so it is what it is. People are who they are. I don't know what to tell you.
There's an interesting generic comment in this particular article that we're addressing right now, where somebody who actually runs a support group for young men says they know they're not supposed to be toxic, but they also know they're expected to be stereotypically masculine if they're going to be taken seriously by the girls that they're interested in. Yeah. And, this is the kind of comment that I don't find that helpful at all, because it treats men as if they're all a type. And that's what we try to avoid about women, and we need to avoid that about men too. And just because somebody's engaged in sports...
Talk about that a little bit more, because I think this is very palpable. This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record. And now back to our podcast. Thank you.
There's a concept right now that, and sure, there's hazing that goes on at universities.
Oh, yeah.
And there's hazing that goes on, in sports clubs and things like that.
Sports teams, absolutely.
But to say that any young man who's involved in a sport is going to exhibit toxic masculinity or try to fit a stereotype about men is just as wrong as making stereotypes about women.
I agree. And it's prevalent, and we've seen instances of this abuse, but as much as there are those instances, there's thousands of other instances where it doesn't happen.
Yeah.
Right? We have lots of healthy relationships of athletes with other people, with people who are members of sports groups, who are members of fraternities, and, et cetera, et cetera.
Yeah, and, and just to reiterate what I said a moment ago, we cannot put stereotypes on men just as we can't put stereotypes on women. We absolutely cannot. And that's, I think, what a lot of these cases, not just the Hockey Canada case, but anything involving an athlete who's male. We see that all the time. Talk
about my fear. And then I'd voiced this, and then a CBC article came out, I guess, on the 14th. And it's a fear that sex assault trial reforms, which followed the Ghomeshe case, will now follow the Hockey Canada case, which is what I said on air. Of course, CBC didn't quote me here. But God forbid they should.
Let's clarify what the Ghomeshe rules are. We know, and we've done podcasts on it, but there was
the majority of our podcasts have been on it, but anyway.
A lot of them.
Yeah.
But so new rules were passed in terms of the defense having to bring pretrial motions because there was an unpopular case, a publicly unpopular case,
Highly unpopular.
in which a high-profile individual was acquitted, and the public was outraged because that individual was able to confront the complainants, all three complainants, with inconvenient text messages and emails and such that the complainants were surprised that he still had possession of, because these were
that they wrote.
historic
These are
allegations.
communications between the complainants and Mr. 𝐵𝐲𝐶, which they obviously had written and they knew about, but they were surprised by it because they didn't think years later he would have kept them.
Many years later, and they didn't know, because he didn't have to bring a pretrial motion to disclose everything in this possession. They didn't know that they were going to be confronted with these, and so they were caught by surprise, and they had to try and flounder their way through it. And ultimately, because of that, they weren't believed, and so legislation got passed.
That wasn't the only reason they weren't believed. There was collusion. There was a ton of other things.
Oh yeah, there was like 40,000.
But these messages were exceptionally fucking compelling. It was like shooting fish in a barrel. Yeah. There's no way he could have been convicted of these offenses based upon these messages. And now what came out of this was an amendment. So we're just going to drill down a tiny bit, because we've talked about this we're over 170 episodes. So we maybe talked about it for 147 episodes.
But we're worried that new legislation is going to be proposed and potentially passed.
But everybody knows this from our podcast reviews. But so messages now have to be vetted through a court. You have to have an affidavit and an application, and you have to ground it in relevance and all that other stuff. Okay. So now I was fearful that because of all the shit going on around this Hockey Canada case and what may be, a complete acquittal of all the accused, which. We don't know if that's the outcome yet. We don't know if that's the outcome, but leaving that aside, I think the evidence is compelling in that regard. We're worried now that there's going to be a new slew of laws or a new regime about video evidence or something else.
Because, I find a lot of this legislation tries to reverse engineer acquittals. So they look at why people get acquitted, and then they try to figure out how to pass legislation that'll prevent that person from being acquitted. And, they reverse engineer this stuff, sometimes using pseudoscience. And when I say that, I mean things about memory, things that aren't solid science. And we're talking about like people that practice recovered memories, as I've said before, pseudoscience about, how trauma affects your brain and your memory and things like that. Reverse engineering to prevent acquittals once there's an unpopular acquittal. And so that's what we're concerned about, is that they'll be concerned that the public, because there is a concern that the public maintain faith in the judicial system.
This is always about the misperception of the public. I was on radio today, and every time I'm asked to comment, I am constantly barraged by how our system is broke. It's not fucking broke. Okay, we complain about stuff, but by and large, we are extremely fortunate to have the criminal justice system that we have here in Canada. There are extremely good appointments of both Crown attorneys and defense lawyers to the bench who want to do a good job, and they fairly assess everything. And we have a good process. I may not like disclosing all of these messages. We found a way to work with it, so be it. But reactionary legislation to unpopular cases that make the public feel that the system is broken is not the way to enact law.
You can't change legislation because you didn't like the outcome of a particular case.
Right, you can't change the criminal code because this one fucking case that happens to get all this media attention, this one fucking case pisses off a group of people in the public, and as a result of that, the government goes, oh, well, we're a left-wing government. We're going to have to do something about this. We're going to have to increase convictions, and we're going to have to make the public feel that that's what we do. We convict people.
Right.
That'll make them feel better. Yeah. Until I go into the lawyer's office, it's my family. Yeah. Oh, how did my son get charged? Well, you didn't pay attention to what that fucking politician was saying.
And
right?
how that could affect people that you presume it's never going to happen to you. And, there's...
Every time somebody comes in, our clientele, it's like, how can this happen? And I'm like, does nobody pay attention?
Yeah, and, so one of the things is understanding protecting the legal system is protecting yourself. It doesn't mean that you're protecting people you think are guilty or whatever.
Absolutely.
And
these rights are for everybody.
Yeah, and that, instead of focusing on whether or not you like the outcome, you should be looking at whether or not the system worked the way it's supposed to.
How about you look at the fucking evidence and go, you know what? I don't think the Crown has proven that there was lack of consent beyond a reasonable doubt, and therefore the person should be acquitted. Because we have the presumption of innocence, we have proof beyond a reasonable doubt. But no, you know what we're going to do? Here's my fears. We're going to deal with video evidence differently in sex assault cases now, where it's like a consent video, or maybe we're going to around with the definition of consent more.
Okay. So here's an interesting...
That's all you have to say is K? Because I'm worried that they're going to do
lose
something to the definition of consent. I'm terrified about that.
Yeah, well, I know, and that is actually one of the concerns that was expressed in the CBC article.
I didn't really read it because I wasn't quoted in it.
They talked about how they could try to change the meaning of consent. We already know that consent has to be...
It's under attack already.
Active and ongoing.
The definition of consent's been under attack for a while.
But I didn't want to lose this thought. This type of video, where they have somebody saying, yes, I consented to what just happened, would normally be called the subject matter of the charge, correct?
Yeah.
And so what does that mean? Explain that.
So if you have a video immediately after the sexual encounter and you're discussing what just occurred, what the actual encounter, you're just discussing what occurred, and that is what the offense is. In other words, what she's saying she consented to is what she's saying now she didn't consent to. That's the subject matter of the charge. Therefore, that video does not need to be pre-screened by a judge.
And the reason is because...
But it's a record.
Her version and his version are both seen as equal in terms of addressing the subject matter.
But it's a record. And as a record, it still has to be vetted.
Yeah. But if it's seen as, if it's determined to be subject matter of the charge, then it's, sometimes it doesn't have to go to stage 2.
I
it's
agree.
Too complicated.
I still think, based on the case law, that if you have, let's take these people away. We have a case where two people have gotten together and then afterward they're videotaping and they're talking. They're saying, hey, the sex was great with you tonight. Yeah, it was really good. You certainly loved it. Oh, I absolutely loved it. Did you consent to it? Of course I consented to it. It was amazing. Okay, great. And that's the end of the video.
Had a great time. Love you, baby. See you tomorrow.
So you have that video. It's not advisable to just spring it on at court. It's a record. It is technically about the subject matter of the offense. It should be screened at stage 1 and then be determined not to be a record. But according to the legislation, it's a record. So it's going to have to go before a judge at some point. So that's going to happen.
Well, we always try to err on the side of caution to make sure that we're not...
I don't think it's a good practice not to do that because it's just going to go before the judge. It's not going to be a record under stage 2, in our opinion, in our expert opinion.
Now, an exit video is more important than an intro video. So recording
both are important. One can imagine.
Yeah.
But I can imagine all the machinations of these experts saying, well, an exit video is because they're under pressure.
Which is one of the...
Or after they had sex,
after
sex, they consumed two scotches together. Mm-hmm. And therefore she wasn't, of her right mind at the time. I mean, I can think of any number of excuses that these experts are going to come up with as to why it's not relevant. The question is, it's not for any expert or any person in the public to go, this, therefore, it shouldn't go in because it's skewing the analysis. No, it's not. It's a piece of evidence that a judge or a jury can assess overall to determine whether the Crown has reached its threshold of proof beyond a reasonable doubt that there was no consent. It's a piece of evidence. But I'm terrified that they're going to put more parameters on these types of videos, and they're going to screw around with the consent definition more.
Yeah.
And consent is already a subjective concept.
And I think the way they'd... I don't want to give suggestions. Actually, I'm not going to say it.
No, say it, because if it comes through, we'll look like we knew about it, like we had good forethought.
I think that there's a possibility to deal with this in terms of increasing the probative versus prejudicial effect standard, because there's.
I think legislation would be unconstitutional at that stage.
Yeah, the probative. The Supreme Court's already said that it has to be more than trifling. That's what probative means.
That's what significant probative
value means.
It's not a high threshold.
Yeah.
It's an unfortunate term. Significantly probative means more than trifling. Well, that kind of seems stupid. You could have just said it has to be probative. But,
right.
But I agree with you. And I don't
in the
think
French version, that's all it says.
And JJ's already said if it was a higher threshold, that whole regime would be unconstitutional. Yeah. So I don't think they can play with that. But I'm worried somehow that they're going to play around with consent more. And I'm not sure how they can do it because I already think it's a highly subjective element. that you can attack through all sorts of means, but it's a subjective element. It's defined in the criminal code. It's defined by the case law, and but I just think it's a concern here because of the outcry from this.
We're so careful in our applications, though. Like like an intro video where somebody says, like, hey, you totally want to do this? You're okay with this? And they say, yeah. And it's before this, any sex takes place. That doesn't mean they continued to consent.
I agree.
But it becomes more relevant if the complainant says that they entered the situation in a very different manner. That they were, say, grabbed, and like we have in one of our cases, I was pulled into the room, and then we have video evidence showing that they walked hand in hand, right? So it becomes more relevant when it contradicts what the complainant said.
100%.
And so this is the stuff that's made in submissions, argued in submissions. The evidence itself, as we've gone over, we've had some great decisions, especially from Pachoco and JC and stuff, saying the evidence itself is not the problem. It's the inferences made from the evidence. And so I think what we're concerned about is that evidence that could have some significance is going to be blocked straight out and not be permitted in the trial, and it's going to prevent the trier of fact from getting to the truth of the matter.
Yeah, and what that will lead to then is, again, more constitutional applications all the way up to the Supreme Court of Canada. Huge uncertainty as to how we deal with these cases. Maybe we're just crazy. Maybe we're just so gun shy now. We're so shell shocked by what's gone on in the past.
You predicted it, and then all these, this article is saying there's a bunch of other lawyers who are concerned about the very same thing.
I'm in good company in being worried about it, and I was worried, for the last couple of weeks. Particularly worried last week when these comments came out, and I just think these experts could just simply say, look. I think it's a fair comment to say that at the end of a session in a case where, I don't want to comment on this so much, but a person could feel compelled to say it was consensual. I get that. That's an argument that can be made, and it may have legs. That's fine. But everybody gets to be cross-examined on the video. The video can go before the judge. We have very good rules of evidence in the way that we can draw inferences from it, and let the trier of fact, a judge or a jury, make that determination.
And when young men feel the need to try and get recorded consent, they're not misogynists. They're scared. And I'd say for good reason.
Yeah, look, to have balance, I think there is an element out there that has, you look at the Tate, and, there's an element of people out there that are inherently predatory with respect to male-female relations, and that's a different area. And there's a lot of dark shit on the internet in so many spheres. That said, there are a lot of people who are very worried, a lot of young men who are very worried. And we've said this before, that the way we're crafting things now and how it's being framed in arguments that really frame men as having toxic masculinity, being misogynistic. Why would you ever do this video if everything was okay? The framing of this makes some people very, very nervous and very, very scared. And it has an impact on human relations. And if you think that people won't go out at night and have a few drinks and then wind up together and then may not wind up together after that, it's just fantasy. Go to Las Vegas, go to anywhere you want. People will have fun because in human nature, that's just the way some people behave. And they just want to have a good time and everybody's cool with it. And sometimes there's nothing that comes out of it. But people get scared because of the way this is framed and how people are framed as to being misogynistic or being predatory or being abusive, et cetera, et cetera. And I just think there's a legitimate fear. How do we deal with this? I don't know. I think we have to tone down the language.
And the answer is not to create more legislation, complicate everything.
No more reactionary legislation. We've had too much. I hated what they did to jury selection. That was a horrible piece of reactionary legislation. The Supreme Court in Chohan said it's okay. And I think it's just obliterated my desire to have jury trials.
And the reason we don't let the public outrage determine our laws is because the reason we have a very well thought out legal system is because vigilante justice is not a good idea.
Well, but just think about this for 1 second. Just 1 second. Our justice system is under attack a lot publicly. And I have respect for people who are elected representatives. But when they compare our system to, portions of the United States where you have elected judges, and maybe we should just elect judges because they feel the will of the masses, and therefore they'll execute their duties in office the way that the masses want. That's what we should be fearing. And the misnomer about it is in the United States, it's a far small percentage of judges that are elected compared to those who are appointed either in the state and certainly federally who are appointed. And I just feel that the constant attack of our system undermines the actual public's true understanding of what's going on. Spend the time in the courts. Go into a Zoom link and watch some trials. Watch bail hearings. Go into the courthouse and watch. You know what? We don't have reporting like we used to. Right? We just don't. There's no real crime reporters who are in the courts all the time watching. We don't have the public who's generally interested to go. There used to be a time where, you could find many public members sitting there just watching trials because they wanted to. That doesn't go on now. The public needs access and they need to know what's going on because it is a functional system. We will continue to complain about certain things because we want to advance rights. We want to make sure evidence is interpreted appropriately. But by and large, again, this is a very good system. It's not going to be f***ing perfect. It can't be. It's an exercise in human nature and psychology. But the public needs to be better informed, and they're not going to get their information by shitty reporting and by, off-the-cuff comments by certain politicians who want to change the system that would be to the detriment of everybody.
I generally, I like to live my life more as an optimist than a pessimist, but one of the things I've said before is the reason that they stopped having public executions is because the public liked it too much.
Yeah.
They had parties. And that's one of the reasons why our legal system is so important. And that's one of the reasons why, the public, however they may feel, can't be put in control of legislation just because they have an emotional reaction to something.
Look, they can vote every 4 years or whatever it comes up when we have elections. If you have a minority government, you can vote and let your vote be heard as to who you want. But politicians have an onus to be careful, appoint people who are, the federal justice minister or the provincial attorney general who know what they're doing and who understand and why we can't do certain things and what separates our system from a closed society. And we have to protect these rights because, frankly, people fought very hard in wars to ensure that we had this democracy that we could enjoy.
Yeah.
Vacation. A little bit of a vacation.
But
a bigger one for you.
By the time this goes online, I'll be swimming in Georgian Bay.
Hopefully it'll be at least 76 degrees for you. Pillow Talk, please don't forget to like, share, and subscribe. Hit notification. Send us comments. And when the podcasts do drop on Sundays, we're on usually with these active commentaries, and we get some great ideas. So thank you for all your viewership. Thank you, Easy DNS. Have a good night and take care.